Renraw Investment Resolution to advance the against real-time systems limited.
Good morning, Mr. Chairman.
Good morning, my Lord. Yes, I appear for the appellant today with Mr. Kyle Taklal Singh of Trinidad and Tobago and Mr. Nicholas Lear. And against me are Mr. John Jeremy, Senior Counsel of Trinidad and Tobago, and Mr. Richard Thomas, King's Counsel.
Thank you.
Well, my Lords, this appeal is brought because the Court of Appeal overturned a trial judge's finding of fact when it had no good reason to do so. Of course, Justice of Appeal Smith, who gave the judgment of the Court of Appeal, didn't set aside the judge's findings without first referring to the board's cautionary reminders of the principles of appellate restraint in Beacon Insurance, in the Beacon Insurance case, for example. But he didn't go on to observe those principles. And this
is a case where I think there's no dispute as to the principles to be applied. The question is, did the Court of Appeal apply them?
Indeed.
Yes.
Yes. And in this case, the question before the judge was a pure question of fact. Was the money paid by the appellant to the respondents a loan or a gift? Or in other words, with what intention and under what arrangements did the appellant make the payments to the respondents? And there was evidence on both sides of the question. The judge found, on the balance of probabilities, that the payments were made by way of loan. There's no suggestion that that finding wasn't open to him on the evidence, or that it was one that no judge could reasonably have reached, nor is it suggested that he misdirected himself in law. So in the absence of any of those factors, the appellate court could only be permitted to intervene if the judge had made a demonstrable error in his approach to the evidence sufficiently material to undermine his conclusions. My Lord Hodge said that the principles aren't in dispute, and I've referred to the summary of the principles of appellate restraint that was given by the Court of Appeal in Volpe. And I know your lordships will be familiar with these, and they've been repeatedly expressed in this court and in the Supreme Court, but I would just like to have them in mind, have them expressly in mind when we look at the Court of Appeal's reasons for setting aside the judge's findings. So if we could go to Volpe, which is as good a summary as any, that's 1181. And Lord Justice Lewison's account of the principles is 1182. Well, they're in the head note as well. But so paragraph 2 is, I submit, an accurate summary of the principles of appellate restraint. It doesn't matter with whatever degree of certainty that the appeal court considers it would have reached a different conclusion. What matters is whether the decision under appeal is one that no reasonable judge could have reached. The appeal court's bound, unless there's compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into his consideration. The mere fact that a judge doesn't mention a specific piece of evidence doesn't mean that he overlooked it. The validity of the findings is not aptly tested by considering whether the judgment presents a balanced account of the evidence. The weight which he gives to the evidence is preeminently a matter for him. The appeal court can therefore set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally insupportable. I'd probably just add At 5, tribunals are free to draw or to decline to draw inferences from the facts of the case before them using their common sense. And Lord Justice Lewison refers to a number of authorities for all those propositions with which your lordships will be familiar. There's one, though, that I will go to, which is Henderson and Foxworth, because that contains a passage from the judgment of Lord Reed, which was alighted upon by Justice of Appeals Smith. So Henderson and Foxworth is at 711. And Lord Reed's discussion of appellate restraint begins, I think, at well, the relevant part begins at 7:30. And there at paragraph 62 is the well-known discussion of what plainly wrong should mean. And then there are various expressions of that principle. But the passage that is quoted in the Court of Appeals judgment is that at paragraph 67 over the page.
This is the paragraph they focus on.
Yes, this is the Court of Appeals paragraph. Yeah. It follows that in the absence of some other identifiable error, such as, without attempting an exhaustive account, a material error of law, or the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, etc., an appellate court will interfere with the findings of fact made by a trial judge only if it's satisfied that his decision cannot reasonably be explained or justified. As I say, that passage was alighted on by Justice of Appeals Smith, alighted upon, but in my respectful submission, misapplied. Because Lord Reed's comments here are not an invitation to the appellate court to find ways of expressing its disagreement with the trial judge so as to find an identifiable error. And they're not a license, in my submission, to ignore the restraints that we've just seen summarized in Volpe. To take an example, the case law is clear that it's not enough to set aside the judge's findings for the appellate court to take the view that it would have given considerably more weight to certain factors than the trial judge did. That's not a reason to set aside findings. It must follow that the Court of Appeal, the appellate court, can't free itself of that restraint by describing the difference of views as a misunderstanding of the evidence by the trial judge, to use one of Lord Reed's categories. But I say that's exactly what the Court of Appeal have done in this case. They've converted their disagreement into the judge's misunderstanding of the evidence. Now, I won't re-argue the facts before the board, but I do propose to consider the evidence and the judge's findings in order to address the Court of Appeal's criticisms. So starting with some agreed facts or undisputed findings, it's agreed that the appellant paid about 1.5 million TT dollars to the respondents in October and November 2007 by a series of 5 checks. And the checks were given to the third respondent, Mr. Warner, by Mr. Lalla on behalf of the appellant. The judge found, accepting the evidence of the respondent's witnesses, that these payments were part of a larger number of payments made by Mr. Lalla or businesses associated with him to Mr. Warner. And if reference was needed for that, for example, page 72, paragraph 41, that's the judge's finding. Yes. That's right. And the judge found that these payments were made for the purpose of funding the 2007 election campaign of the UNC, the United National Congress. And that finding wasn't disputed on appeal by the appellants. But in making that finding, the judge accepted the evidence of the respondents' witnesses, rejected the evidence of Mr. Lalla, who had denied that the payments were anything to do with the UNC. He had said that loans were made because Mr. Warner said that his businesses needed money.
Yes, Mr. Lalla's evidence on that was simply untrue.
Yes.
So he was incredible on that matter.
On that matter, yes, my lord, yes. And the judge described that as a significant flaw in Mr. Lalla's account. Now, both Mr. Warner and his witness, Mr. Hussain, described meetings at which Mr. Lalla agreed to make funds available for the UNC campaign. Mr. Warner's is at page 316, para 11. And actually, that's just the conclusion of the meeting. 315 for the rest of the meeting. And Mr. Hussain is 321 to 322. 322, paragraphs 11 to 13. And the judge accepted that evidence. There were meetings at which...
So which paragraph in Mr. Hussain's?
11 to 13, page 322. The judge basically accepted this evidence. There were meetings at which Mr. Lalla agreed to make funds available for the UNC campaign.
Could I have the page number again? 322?
322.
Thank you.
Paragraphs 11 to 13. That's
Yes,
Mr.
I have it
Hussain's.
now. Thank you.
During another meeting. But at those meetings, there was no express agreement as to the terms on which these particular payments would be made. Nobody said, for example, this is going to be a loan or this is going to be a gift. And it was common ground, in fact, that if Mr. Lalla and Mr. Warner discussed specific terms of these payments, they did so alone. You can see that in oral argument at page 523. In fact, just so that your lordships can see the beginning of the question, it's at the page before 522. And this isn't directed at the question of whether it's a loan or a gift. This is directed at the question of whether this was election financing or not. But the answer applies equally to all the points, because the judge asks the Respondents' Counsel whether Mr. Phillip says that in relation to this specific payment, that was on account of the election financing. The answer is, at line 5, he doesn't say that, and he couldn't, because the facts were that it was Mr. Warner and Mr. Lalla there alone, so he couldn't. So it's common ground that when the two men made arrangements for these payments, they did so alone. That's where the undisputed or findings or common ground comes to an end. The next step is that after Mr. Lalla had agreed to provide money to Mr. Warner, he contacted Ramila Maharaj, the general manager of the Appellant, in around August 2007. And he said he'd been approached by Mr. Warner for a loan and asked the Appellant to lend some money to the respondents. And that was the evidence of Miss Mirage, which the judge accepted. That's para 5 of her witness statement, which is at page 295.
She was the general manager of the claimant.
Yes. The judge accepted her evidence.
He accepted it as credible.
Yes.
Yes, which rather takes the teeth out of any argument about lack of records and so on.
Yes. And he accepts, he makes a specific finding that she acted on what Mr. Lalla told her. She acted on the strength of what Mr. Lalla told her as well. I think that's at paragraph 45 of his judgment.
Yes, so there's contemporaneous evidence
Indeed.
of Mr. Lalla's representation.
Yes.
Yes, and secondly, she was acting as general manager of the claimants
Yes.
and behaved accordingly.
Yes. That's what I take from that evidence. Yes, my lord. And soon after that, on the 15th of September, Mr. Warner emailed Mr. Lalla, which is at page 279, with the subject promissory note, attaching a draft promissory note, which is the next page, 280, by which Mr. Warner would offer to be personally liable to repay Mr. Lalla $20 million. So this is the makings, at least, of a request by Mr. Warner for a loan of $20 million and an offer to be personally liable to repay it. Now, this promissory note wasn't executed, and the terms on which Mr. Lalla said the loan was eventually made were different from the terms in that promissory note. So this note doesn't go all the way, but it is the makings of an offer to be personally liable to repay. And then 26th of September, the next page, 281. So I say it shows the circumstances in the context in which these matters were being discussed, if nothing more, and the probable intentions of the parties. And that's how the judge took it. Next page, Mr. Warner chasing up his email, any progress, and he gets a positive response from Mr. Lalla, yes. That's the 26th of September. And it was about 2 weeks later that the first payment was made by the appellant. The first check was dated the 9th of October, 2007. Now, after the payments, other emails passed between Mr. Lalla and Mr. Warner, which the judge found instructive as to the arrangements between them generally. I accept none of the emails discuss the appellant's payments directly, none of them set the terms of a loan or amount to an acknowledgement of the appellant's loan, and the judge didn't say that they did any of those things. Rather, in his...
Just a matter of interest, did Mr. Lalla also act under the name of Raj Nanan?
Yes, he did.
Because I see the email
Yes.
address repeatedly uses that address.
Yes, he does. Yeah. Sorry, I should have said so at the start. My apologies.
Yes.
So, yes, the judge doesn't rely on the later emails as setting the terms of a loan or amounting to an acknowledgement of a particular loan by the appellant. Rather, in his words, they led him to the view that the financial arrangement between the two men was characterized by an expectation of repayment. That's how he put it. And he also found that Mr. Warner had, in fact, made promises of payment to Mr. Lalla. The particular emails referred to by the judge are those from December 2007, which are page 286 and 287. And in December 2007, Mr. Lala, or under the name Raj Nanan, emails Mr. Warner to say that the banks need answers on loan monies advanced. What do we tell them are the repayment terms? The monies didn't hit the account. Mr. Warner says he'll investigate, and he says he asked for time. He asked Mr. Lala to see how much time he can get. He says he's swamped with debts and being harassed every day regarding the payment of outstanding bills. And then the last line, everywhere I go, I'm looking for loans, I'm looking for help. That's 286. 287. Mr. Warner, again.
So this is Mr. Lala representing to Mr. Warner that Mr. Lala's bank is wanting an explanation.
Yes. Now, I accept that this is unlikely to be with specific reference to the appellant's loan, because Mr. Lala said that was repayable in February 2008, and this is December 2007. So the judge is looking at this as the overall financial arrangement between the two men.
Yes, because as we read on in the emails, the sums involved were considerably greater than 1.5 million.
Yes, indeed. And the judge so found, yes. And yes, Mr. Warner's response is to say how difficult he's finding it to find money and to repay outstanding loans, but he's looking for more help and more loans. And the same thing, he says the same thing on the next page to Mr. Lala also on the 7th of December. And this is with the header UNC payments. Just can't make any more. I've borrowed from every conceivable source, and yet there are still so many persons to be paid. So that was the first set of emails that the judge found instructive, and the second is the next page. Some exchanges in January and February 2008. So I'll pick it up.
Which page you want now, please?
288. So we have the first, if you like, inset from the bottom of the page. Mr. Lala, under the name Raj Nanan, refers to a meeting with Jack Warner on the 25th of January regarding the repayment of loans. And then the next one, heading up the page, is chasing a response. And then up the page again, we're now in the 7th of February. At the meeting on Saturday, 26th of January, you mentioned I would receive $1 million on the 6th of February 2008. You didn't give me any reply to my email. Here under Jack, this matter's urgent. And then Mr. Warner's response. I'm awaiting the transfer of money from Zurich. I don't recall giving you a date of February 6th, but if I did, I'm sorry. I did say, however, the money is due in February, $2 million, of which I shall give you $1 million. And then he says...
What date was the loan of 1.5 million to be repaid on?
In February 2008. I don't
just in February, rather than...
I think I'm right in saying there wasn't a specific date, but I will just check what the judge's finding was. It was agreed, the judge's finding was it was agreed that the said loans would have been repaid by February 2008. So this is the email we were looking at again, back again at 288, is where the judge finds Mr. Warner promising to make a payment to Mr. Lalla. And then finally, Mr. Lalla he appears to be replying to an email that's come in between, but he says, hereunder is an email from yourself replying to the same mail that you're claiming you didn't receive earlier. We're missing a couple of emails here, but Mr. Lalla is referring back to this email below. You indicate you'll honour your promise. I'd like to know, what is the promise? I hope it's what you promised when you requested these loans. I await your urgent response. So, when the judge discusses these emails, his findings are at paragraph 39 and 41, and they begin at page 71 of the record. So paragraph 39 is where the judge deals with these. He summarizes the emails we've just seen, and his finding is this: the correspondence demonstrated that the financial arrangement between the two men was not gratuitous, but was one characterized by an expectation of repayment. That's the first finding. The second finding is, and representations as to part payment were in fact made by Mr. Warner. Then he goes on to discuss what that assurance of payment was likely to mean. He makes the point that Mr. Warner has been repeatedly saying how hard he's finding it to find money and how many outstanding debts and liabilities he has. So if he was offering to pay Mr. Lalla $1 million, it wasn't gratuitous. He must have felt, or at least in the judge's view of the balance of probabilities, it was likely to be because he felt obliged to pay Mr. Lalla some money. It's improbable, as the judge said, he would have been advancing or promising to give Mr. Lalla a gift.
Well, in a context where a judge is faced with evidence of two substantial business people, neither of which he is accepting completely, then the contemporary documents obviously assume a much greater importance.
That's what I say, yes, my lord.
Yes. But the documents which the judge is discussing here all relate to considerably larger sums,
yes, as
we see on page 290.
Yes, we do.
Which is unsurprising because Mr. Lalla is a very substantial businessman.
Yes.
The bank might not be as concerned about 1.5 million Trinidad dollars compared to the sums here recorded.
No, that's right.
He's talking about 75 million,
yes,
which include 29.5 million checks payable to Mr. Warner's companies.
That's yes.
So the judge, I think, has inferred, which he may well be entitled to do, that the 1.5 million is included in the checks payables to the companies.
Well, yes, my lord, and you'll see that the Centre of Excellence, which is the trading name of the respondents in this case, is listed there under the checks payable to your companies.
I noticed that.
Yes. And it also was the evidence of the respondents' witnesses that when various businesses of Mr. Warner were identified as the recipients of funds, it was within the context of a large number of payments and a large number of recipients, of which the Centre of Excellence was one. That you'll see that Mr. Hussein's paragraph 13, which we looked at before.
Thank you.
Yes, so we were looking at the judge's treatment of the emails, paragraph 39, and then he makes further findings about them. That was page 71. He makes further findings about them at paragraph 41. So this is the judge discussing all of the emails. And then over the page is where he makes his finding about the emails in general, which is his finding against Mr. Lalla. It's the last part of paragraph 41. The emails led the court to find on a balance of probabilities that Mr. Lalla advanced significant sums to Mr. That's my Lord Hodges' point. This is part of a much larger amount to Mr. Warner prior to the 2007 UNC election campaign.
Yes. So he's inferring from the emails you've referred us to and page 290 that the 1.5 million is part of the overall lending.
Yes. I'd say he's well entitled to do that from the evidence we just saw and the evidence I discussed of the respondents' witnesses, that a number of companies were identified to receive money under this UNC funding arrangement. So then, having found that the arrangement was characterized by an expectation of repayment, the judge then turned his mind to the inherent probabilities. And he picks up what was put to Mr. Lalla by the respondents. Paragraph 42 and 43. That's the suggestion that this was a quid pro quo, that by donating money to the UNC in 2007, when the UNC was in power, Mr. Lalla would be at the front of the queue for the best contracts, in short. Now, so the respondent's case was, this wasn't a loan, it was another kind of transaction. You give money, you get contracts. But the judge considered considered the inherent probabilities of that given the timing of Mr. Lalla's, of the appellant's claim. He says that the background is that the UNC lost the 2007 election campaign, but won the 2010 general election in partnership with a smaller party. And so, as the judge says at paragraph 43, it's probable to conclude that when the partnership formed the government, that's 2010, having lost the 2007 election, the stars would have been aligned, as Mr. Lalla then stood to benefit from his years of loyal support. And it's unlikely he would have undertaken any act to undermine his relationship with the government of the day. It's important to note there's a typo here. The instant action was filed on April 2016 is written. It was filed April 2010, and that's the whole point. It was filed just as a general election was about to take place in 2010, and it was pursued after the UNC took power in partnership in May 2010. So that should say April 2010 there, and then it makes a lot more sense. Because it was filed in April 2010, as you can see from page 5 of the bundle. So the judge found it difficult to accept that Mr. Lalla would jeopardize the benefit of all these donations by resigning from one donation and saying it was a loan after all and bringing a claim against Mr. Warner, just as Mr. Warner was taking power.
Pages 105 to 111 of the trial bundle are which?
Those are the emails.
Which pages?
Yes, the ones that we have just been looking at. So it would be 280.
Check.
Yes. I think we're talking from 287. Sorry, I beg your pardon. 28. Yes, I think it is 287. Where we were just looking at just now, the December and February emails.
It'd be useful if that could be checked, because
Yes.
we need to identify which were the pages that the judge was
The
relying
judge
on.
uses the same page numbers when he talks about the emails and makes the finding at the bottom of paragraph 41. He refers to the same pages, having described the emails.
Yes.
If you see, so paragraph 41 begins by describing documents at pages 105 to 111, and then he describes the emails.
He refers to the pages 3 times, yes.
Yes, and then he says again at the end of that paragraph.
I think it would be useful for the
Yes.
board to know exactly
Precisely
the
which
exact
emails.
match.
Yes. See what I can do over the break. Right, so having then taken that view on that particular part of the respondent's case and the inherent probabilities, the judge goes on to make his conclusions, and they are the first part of paragraph 44. So the court considered the evidence in the round, the emails, the subsequent events after May 2010 with the formation of the partnership government. On a balance of probabilities, felt it was more likely than not that Mr. Lala advanced to Mr. Warner significant sums, but the sums advanced were made available pursuant to loan arrangements. And then, so that's a critical finding. The judge then goes on to make findings as to the surrounding circumstances which help him to explain this. And for the most part here, he's accepting the evidence of Mr. Hussain and Mr. Phillip, the respondent's witnesses, and Mr. Warner himself. Mr. Phillip was the one who gave evidence of a shadow election campaign, and Mr. Warner and Mr. Hussain gave evidence of a clandestine political alliance, whereby the plan was to change the direction of the party and put Mr. Warner in as the leader of the party instead of Mr. Pandey. There is a finding there with which the appellant, with which the respondents and the Court of Appeal took issue. That's the last finding on the page. On a balance of on the paragraph, on a balance of probabilities, this court's of the view that Mr. Warner may have wanted to portray an image to the UNC that he was its main financier, but to do so he sourced finance from Mr. Lala. And that's the bit that the Court of Appeal took issue with.
I struggle to see why that is significant, because if Mr. Warner is asking for money either as a gift or as a loan to his companies to spend on a political campaign, then it must be because he wishes
to wield the influence
to be the person who is seen as spending the money.
That's my point.
It seems to me a perfectly legitimate inference from the request that political funds are made available to Mr. Warner's company.
Yes. And my lord, you've shortened my arguments.
It's at the end of that paragraph where he says the expectation sums will be repaid upon receipt of this payment due in February.
Yes.
The finding he makes at the end of 45 is that it was to be repaid by February.
Yes.
Consistent with the funds coming in February.
Yes, there is an inconsistency there, my lord. I accept that.
The evidence of the $10 million US, I think it is from FIFA, was that Mr. Lala's evidence? Or,
yes.
Yes.
And it's backed up to some extent by the emails we saw, where Mr. Warner says, "I'm getting $2 million from FIFA in February. I'm going to give you $1 million."
Yes, but 2 million is an awful lot. 2 million is an awful lot less than 10 million if you're in financial trouble.
Yes. Well, as to who promised how much it would be to Mr. Lala, that must be Mr. Warner. But
yes,
I dare say that the judge would be entitled to find that a large sum was promised to be coming from FIFA because of the size of the sums that Mr. Lala was prepared to make available up front. But I would say that whether the promise was, however large the sum was that was promised to be coming from FIFA, or the exact time when it was promised, isn't in my submission material to the judge's finding that this was a loan rather than a gift. And then again, we'll just just finish off with the judge's findings, because the concluding findings actually come at the end of paragraph 45, when after the judge again summarises what he gets from the emails. He then makes his concluding findings, which determine the case. And that's the second half of paragraph 45. The court finds as a fact that there was an agreement in August 2007 for Mr. Lalla to provide or source loans for Mr. Warner to finance their political objective. It was agreed that the said loans would have been repaid by February 2008. The court further finds, this is the finding I mentioned before, that the claimant, acting in reliance on the representations made to it by Mr. Lalla, loaned to the defendant the sum of 1.5 million TT on the basis that the said sum was to be repaid by February 2008. So that's the concluding finding.
May I ask, Mr. Lalla has never resiled from the position that he took in his evidence that this was for different purposes.
Well, I don't know whether it's materials to say whether he's resolved from it or not. The judge's findings were accepted in the Court of Appeal, and they're accepted now. And I'm not sure whether Mr. Lalla has ever been asked expressly to resolve from it.
I was thinking in the context of the proceedings themselves. Not
in evidence before the judge?
Yes.
No. His position, these were just business loans.
Yes.
Yes.
He wasn't believed on that. I accept that, yes. And the judge showed that he was sensitive to having rejected Mr. Lalla's evidence on that point. Now, now I'll turn to the Court of Appeal's criticisms, because they were subject to 4 criticisms by the Court of Appeal.
Trying to understand Mr. Warner's case, and that is, was his case that these were conditional loans, conditional on being repaid in a certain way, dependent upon whether an election was won?
The case was that it was a donation, simply that.
It was a donation, and there would be kickbacks if power was obtained.
Yes.
Kickbacks in the form of government contracts.
Yes. Yes.
That's the quid pro quo.
Yes.
Yes.
Not sure I can articulate the case any better than that, my lord.
Yes.
Yes, the case, they were, yeah, I'm just trying to remember if there's a particular passage in the evidence that describes it any better, but I can't right now. I think that summarises it fairly, my lord. Now, the Court of Appeal subjected those findings to 4 criticisms. At least there are 4 in the judgment of Justice of Appeal Smith, with whom the rest of the court agreed. Justice of Appeal Jones, in her own judgment, made 2 further criticisms of her own. The respondents have said in their case they don't rely on those over and above Justice of Appeal Smith's criticisms. So I'm just going to leave my written case to speak to Justice of Appeal Jones's criticisms.
Yes, I think the respondent's position, if I understand it, is that they are not enough on their own, but and they're focusing on Justice Smith's 4 criticisms. But I don't think they're saying they are irrelevant, as I understand.
I suppose that's fair enough. They are I suppose I might counter that they are the findings of a minority, and therefore they do not form part of the.
Yes, but in any event, it might be said it's difficult to give much weight to them once Mrs. Murad's evidence is accepted as it was.
Yes.
Because it will be up to her as the general manager to make sure that the claimant recorded the arrangement as she understood it.
Yes.
Or up to her or one of her officials.
And to the extent that Justice of Appeal Jones's criticisms are correct in fact, which I say they aren't actually when you look at how the evidence came out.
Yes.
And to the extent they would be correct in fact, they only amount to disagreeing with the judge on the balance of probabilities, which is not a reason.
But all I'm saying is I think you should cover those criticisms as well as the four, because my understanding is the respondents have not thrown them away.
Right.
They're still there, albeit they're not,
Yes.
they're not seen as sufficient in themselves.
I will do then. But let's start with with Justice of Appeal Smith's criticisms. The first one is page 202, paragraph 19. And just as a reminder, actually, let's just start at paragraph 17. This is where he alights on the passage from Lord Reed's judgment in Emerson and Foxworth. And he repeats the wording used by Lord Reed of the different categories when he identifies the errors that he does. So the first is that there was a critical finding of fact made without evidence, and that's that Mr. Warner wanted to portray an image to the UNC that he was its main financier. And my Lord Hodge has already identified one of the key reasons I say why there is evidence for that finding in the choice of the route by which the money was paid. It was paid to a number of Mr. Warner's businesses, so that to anyone unfamiliar with the arrangements between Mr. Warner and Mr. Lalla, it would have looked like Mr. Warner and his companies were making this money available to the UNC. Of course, Mr. Warner's own evidence was that he did want to wield further influence in the UNC using Mr. Lalla's money. His witness statement is at page 315. He said, financiers were deserting the UNC, but in alliance with Mr. Lalla, he could reset the direction of the UNC and unseat the leader. That's if I can summarize what Mr. Warner said. And in his particulars, he describes himself page 31 as the co-political leader and financier of, yes, paragraph 3b, page 31.
Paragraph?
Paragraph 3b, page 31. Mr. Jack Warner, then financier and co-political leader of the UNC. Yes, I'm reminded that in his witness statement he did say as well that he used his own personal, he added his own personal money to Mr. Lalla's. For which the other point that the judge bore in mind was that at the same time, privately, Mr. Warner was telling Mr. Lalla how he couldn't get hold of any money. He was being pressed on all sides. So there was evidence for the judge's finding. I would also add that we've just gone through the judge's findings.
Pardon me.
I wouldn't say, I would disagree that it's a critical finding as well. It's one of the judge's findings about the circumstances which help him explain this arrangement. But the critical basis for his conclusions are an assessment of the emails and this decision that they show an arrangement characterized by an expectation of repayment. So I've dealt with the first criticism rather swiftly, but if your lordships have any other questions about that, if not, I'll move on to the second criticism, which is at page 202. Paragraph 21, which was that the judge failed to properly assess the evidence of Mr. Hussain and Mr. Phillip. In particular, the point taken by the Court of Appeal is that they corroborated the testimony of Mr. Warner in very material particulars. and that specifically being that this money was for the UNC election campaign. And that's the point made by by Justice of Appeal Warner at the end of paragraph 23 on page 203. These two witnesses substantially corroborated Mr. Warner's case that Mr. Lala advanced money to Mr. Warner and his affiliated companies to finance the election campaign. And this is the point being made. It lends credence to Mr. Warner's assertions that the money was not advanced by way of loan. Because, of course, it's not that the judge failed to consider this evidence. He accepted it and expressly said so. He accepted the evidence of Mr. Hussain and Mr. Lala that these were UNC funds to finance the campaign. And to that extent, as we've discussed, he rejected the evidence of Mr. Lala. But the Court of Appeal's proposition, the criticism is, if Mr. Warner was corroborated on an important matter in dispute, and Mr. Lala was disbelieved on an important matter, that would lend credence to Mr. Warner on the main matter in dispute, whether this was a gift or a loan. Of course, that's a fair enough proposition to put in argument.
Yes.
But it doesn't follow, of course, from the fact that Mr. Warner was corroborated on the question of election finance, that he must be believed on the question of gift versus loan.
But it would be relevant to that question.
It would be a relevant question.
It would be relevant. It would be relevant to the second part.
Yes.
Of that issue that you've just identified.
Yes. As I said, it's a fair enough proposition to put in argument to the fact finder. My witness has been corroborated on a very important matter, and his witness has been disbelieved. That lends credence to my witness on the important matter that you have to decide. But it doesn't follow that because Mr. Warner was corroborated on one, that he must be believed on the second. And it doesn't follow from Mr. Lala's evidence being rejected on the first, that he must be disbelieved on the question of gift versus loan.
Yes, the judge has looked at the two evidence of the two principal witnesses, Warner and Lala, and accepted some of their evidence and rejected other bits.
Exactly, yes.
And as far as Hussain and Philip go, they weren't at the meeting where the nature of the deal was discussed, but they nevertheless corroborate Mr. Warner to the extent that the money was being advanced for electoral purposes.
Yes. And of course, as I mentioned before, the judge was sensitive to the fact that he'd rejected Mr. Lala's evidence. He described it as a significant flaw in his account. Somebody else might have used stronger words, but he's shown that he's sensitive to the fact that he's rejected Mr. Lala's evidence. And in fact, when he makes his findings, he doesn't place specific reliance on Mr. Lala's evidence. He refers to the emails and the other corroborating evidence. He does what my Lord Hodge suggested one should do when one finds both principal witnesses hard to believe. One looks at the documentary and the objective evidence. So, the Court of Appeal here isn't not identifying an error on the part of the judge, it's just taking a different view of the probabilities. And that's not a reason to overturn a finding of fact. And third criticism is at paragraph 28, which is page 204. Which was that the judge did not appear to have taken into consideration the very relevant cross-examination of Mr. Lala, and in particular, a concession made by Mr. Lala in cross-examination. And the concession is identified at paragraph 31. which is that none of the emails show that Mr. Warner or his affiliates admitted to this specific loan or any loan between the parties. And my answer to that is nobody ever said they did. The appellant, it wasn't, the appellant didn't.
To say that the emails didn't show the existence of any loan between the parties, that would be a strange concession for Mr. Lala to make. But it's certainly, looking at the emails, they don't
Well, the parties.
pinpoint the 1.5 million loan.
One has to remember the parties here are real-time systems.
I see, yes.
Mr. Lala. So.
Yes, so there's nothing to show that real-time was the lender.
There's nothing to show Mr. Warner acknowledging a loan to real-time systems.
But real-time systems was in the control of Mr. Lala. I mean, Mr. Lala wasn't an independent third party going to real-time systems and saying to it, look, it would be a good idea if you lent money to my friend, Mr. Warner. As I understand it, this was part of Mr. Lala's business empire, is that right?
Well, the way Miss Mirage puts it is that she would because of real-time's regard for Mr. Lala, she would act upon his requests.
What? Who controlled real-time?
Well, I think it would be fair to say it is part of his business empire.
Yes. So yes, he had a degree of shareholder control. Was that the evidence or not?
There wasn't any evidence as to that.
There was no evidence at all.
The judge appears to have taken it that Mr. Lala was, as he later described it, the principal of real time, but he didn't make findings to that in that respect here.
Well, the principal means in effect the controller.
Yes.
Which means at least the majority shareholder.
I don't have any of the details.
But there was no details of that, but it was just accepted that he was, in inverted commas, the principal.
It's accepted that real time would do what he asked.
Yes, and this is not just out of a general regard. This is the fact that it was part of his empire. Yes.
In terms of the specific concessions that are being identified, one's not helped by the fact that Justice of Appeal Smith doesn't identify them. But as far as I take this account here of Justice of Appeal Smith, it was not the case, and nobody ever said that the emails showed Mr. Warner acknowledging this specific loan or any loan made by real-time systems. And neither was it the appellant's case, nor did the judge rely on those emails for any such admission. We've seen how the judge relied on them. So in my submission, the judge's failure to make a specific reference to a concession that, yes, these emails don't show Mr. Warner acknowledging a loan, is immaterial. It can't be, as the Court of Appeal put it, a matter of concern. But still less a reason to overturn the judge's findings.
But paragraph 31 goes a bit further, or any loan between the parties. And that's Renraw, well, it's all of the defendants. I was just wondering, there was the email that set out the loans amounting to 75 million.
That's page 290.
290, right.
The question is whether in any of these emails Mr. Warner admitted to the loan or to this specific loan or acknowledged this specific loan or acknowledged any loan. Admitted, I wouldn't say acknowledged. The way Justice of Appeal Smith puts it is admitted to this specific loan or any loan between the parties. So if one goes back to the emails, one will not see Mr. Warner admitting to a loan. That's accepted. That's common ground in my submission. And the judge doesn't say that he finds from these emails Mr. Warner admitting to this specific loan or any loan between the parties.
Yes, because the emails don't mention the claimant. That is a correct statement.
Yes.
Yes.
And that's how it was put in well, perhaps if I can find the references for the cross-examination, just to... we're in slight difficulty because Mr. Justice of Appeal Warner doesn't...
Smith.
Sorry, Justice of Appeal Smith, thank you. That would be pretty good. Can I try and find the transcripts for the cross-examination later, just in case it assists your lordships? Have a look through the transcripts. Now, and the fourth criticism. Is at page 206, paragraph 35. And this is where the Court of Appeal criticises the judge's view of the inherent probabilities, saying it must be done fairly. In fact, I should say that this is characterised at paragraph 33 as the judge misunderstanding the evidence as it was presented. So that's, again, referring to the categories of Lord Reed. Paragraph 33, misunderstood the evidence. And the reason for saying so is that the Court of Appeal disagrees with the judge's approach to the inherent probabilities and makes two criticisms at paragraph 35. This case was never put to Mr. Warner in cross-examination. That is the judge's theory of the inherent probabilities. And specifically, the problem with that, according to the Court of Appeal, is there was no testing as to whether the continued relationship was the same after 2010 as when the money was paid out. Well, I have three things to say about that. The first is, it was the respondent's express case that the relationship after 2010 was functioning just as was intended in 2007.
So let me note that the relationship after 2010 was
functioning just as was intended in 2007. Because it was the respondent's case. You got your contracts in 2010 to 2015, didn't you? You were in line for them because of the money you gave us in 2007. So it was the respondent's express case that it was functioning. So there's no need to put that particular point to Mr. Warner. It was his case. The second point is, in any event, a judge is not obliged to put his thinking on the inherent probabilities to a witness. And especially in this case, there would have been little point putting to Mr. Warner a theory of what the judge would infer from Mr. Laller's conduct. And the judge did put his thinking on this to counsel in oral argument. And that's at page 529 to 530. So, beginning at line 22, the judge has referred to the respondent's case and saying in the middle of the page, now in 2010, Mr. Laller's poised to reap the rewards. Line 22, why would someone who's poised to receive favourable consideration, where consideration can be given, why would he seek to associate himself now with an action against Mr. Warner and his companies? So he puts that to the respondent's counsel in oral argument. So in my submission, the judge very fairly tested that theory with the respondents. The second criticism made, sorry, we have to go back to paragraph 35 again, page 206. So I'll just read through what the Court of Appeal says here. There's no balancing of the trial judge's assumptions as against the case advanced by Mr. Warner. And then summarises the case put to Mr. Lalla, that he benefited. This was in line with Mr. Warner's case that both parties got what they wanted from their relationship. Mr. Warner got money for campaign financing. Mr. Lalla and his affiliates received benefits as a result of his gift. In other words, the totality of the evidence suggested that it was more probable that the money paid to Mr. Warner and his affiliates in 2007 was by way of donation or gift rather than loan. In my submission, that's nothing more than the Court of Appeal taking a different view of the balance of probabilities, a different view of the probabilities in the case. I think the criticism is that the judge should have considered the probability of the case put by the respondents, and if he had done so, he would have taken a different view. But in my submission, first of all, the judge did consider the probability of that case. We've just seen him testing it against his own idea of the inherent probabilities and asking the respondents' counsel for counter-arguments. Really, all that is nothing more than a statement that the judge should have taken a different view of the probabilities. And as your lordships have said many times before, that is no reason to interfere with a judge's finding of fact. My lords, that concludes what I was going to say about the appeal on the question of fact.
You haven't placed any reliance on Selden and Davidson.
No, because I accept there was evidence on both sides of the case. And so,
does that fall away? That part of your case?
Actually, it may come back when I just remembered I had to go and address Justice of Appeal Jones. So it may come back there. But
you better cover grounds 5 and 6.
Yes. So I'm just going to go to where we've covered that. In respect of what we've just discovered, my lord, I don't rely on Selden and Davidson because I do accept there's evidence on both sides of the case. So if the judge had found the evidence provided by Mr. Warner and the respondents sufficient to make out a case of gift, I accept that there would have been evidence for that, and so there was evidence on which the respondents could satisfy the burden on them in Selden and Davidson. So that's why I haven't referred to it in this part of the argument.
Once one gets into the territory of funding political campaigns, the distinction between gift and donation really will depend on the balance of the evidence, won't it? And you say you win in this case because of Ms. Maharaj and the contemporary documents.
Yes.
It's nothing to do with burden, it's simply a question of the balance of the evidence. The judge was entitled to reach the conclusion he did in your submission.
But where it's a stranger giving someone else money, then in the ordinary course of things you wouldn't expect it to be a gift. Here, it's a bit more nuanced. Yes.
Now, Justice of Appeal Jones, yes. If you'll forgive me, my lords, I'm just going to go to the written case on that. And the first criticism made by her is at paragraph 63. That's page 216. Sorry, these are both of them. She makes both of her criticisms there. The first one is the judge fell into error when he refused to take into consideration the fact that the respondent created no internal documents with respect to the payment of the money. And the second error, when he failed to consider the fact that the respondent continued to provide money even though no security was forthcoming as had been promised. And then in respect of that first point, and this may be where Selden and Davidson makes a minor appearance, because the judge goes on to say, paragraph 64, just pick it up in the middle of the paragraph. It was the respondent who was seeking to have the judge accept that the money was paid by it as a loan. In these circumstances, the manner in which the respondent conducted its financial affairs was very relevant to the case, and the lack of documentation with respect to the loan was an important factor to be considered in his assessment of the nature of the transaction. Now, to the extent that Justice of Appeal Jones is placing a burden on the appellant there, then I say she does come up against Selden and Davidson. But it's perhaps a minor point, because the judge dealt with the question of the lack of documentation and made a finding about it. He took his own view of the balance of probabilities on that. So, and we can see that this proposition about the lack of documentation, can you find a copy of the written case so I can go backwards and forward, was put to the judge by the respondents at length in argument. So it can't be said that it wasn't thoroughly ventilated and thought about. It's page 534 to 537 is where the respondents put their case about the lack of documentation. I won't read it out loud, but your lordships can see the exchanges continuing. From the top of 534, over the course of 4 or 5 pages. And you can see that from the judge's responses that he understands the argument, and he's engaging with it.
Well, if it's a gift for a kickback, I'm not sure you're going to find a board minute about it.
That's right. Indeed, it's a fair enough point. But the judge is aware of the argument. It's certainly a fair enough point made, but the judge is aware of it and he rejects it. Paragraph 31, page 68. So, court's not prepared to draw any inference that the lack of documentation suggests that the sums were advanced as a gift for campaign financing. The court ultimately found that Miss Mirage was a credible witness. In my submission, that's the end.
A registered company in Trinidad and Tobago has to produce accounts with a true and fair view of the money it's allocated. A registered company cannot hand out 1.5 million Trinidad dollars and keep no record of it whatsoever, I would have thought, whether it's a loan or a gift.
Well, I'm not sure how far I can answer that argument on the rules for company reporting. But if a company, yes, it would be the same whether it's a loan or a gift. But the argument I submit is somewhat in my favour, because if a company makes an informal loan, it's still there as an asset on the balance sheet. It's still the company's asset. Even if it was made terribly informally and with no records.
Yes.
If the company's officers reported to the accountants and the auditors that there's this loan and it's repayable, it's an asset on the balance sheet.
Yes. It would depend, I suppose, on yes, it would still be an asset in the balance sheet, whatever. And it's a short-term loan. It's from October, November to the following February. I don't know what the year end of the claimant's company was, but the whole thing might, if carried out properly, take place within one financial year.
Yes, although in the result, of course, the money wasn't paid back, but there was no exploration of what the accounts said.
No.
The point being made by the respondents was, look, the reason why there's no record of this is because it's a clandestine donation to a political party. But one might say the same about a clandestine loan to a political party, in fact.
Yes.
In any event, the judge understood the argument.
Yes.
He took a different view of the balance of probabilities, and in my submission, that's the end of it. And the second criticism of Justice Appellant-Jones was that the respondent gave no reason for continuing to provide money even when the promised security was not forthcoming. The first answer to that is that's actually incorrect on the evidence, because Miss Mirage did give a reason. That's at page 399.
Page
399. Lines 16 and 17. Line 14 is the question.
page number.
It's 399.
399. 399.
399, sorry.
Line 14.
Thank you.
So why then, as a business person, didn't you stop the second check until they get the security? Because of the relationship we have with Mr. Lalla. He promised to get it. So the appellant did give an explanation. So as a matter of fact, Justice of Appeals Jones' second criticism is wrong. I would say as well that it does appear that the judge accepted that evidence, even if he didn't specifically refer to it, because he found, paragraph 31, which is page 68, that the appellant acted primarily on the basis of its relationship with Mr. Lalla, primarily on the goodwill the claimant had for Mr. Lalla, and one of his concluding findings at paragraph 45, page 73.
Sorry, paragraph.
Paragraph 45, page 73. We've seen this before, but it's the judge says, page is frozen, sorry. The claimant acting in reliance on the representations made to it by Mr. Lalla, loaned to the defendant the said sum. So one might say that the judge accepted that evidence of Miss Mirage, although he didn't specifically refer to it. But my principal answer is Justice of Appeal Jones is wrong to say no explanation was given. And if the judge didn't expressly refer to it, that, as we've seen from looking at Volpe, wouldn't of itself be a reason to overturn his finding, because the judge isn't required to refer to every bit of evidence he's taken into account, or every bit of evidence he's accepted. So now I think I have concluded the appeal on the questions of fact, and Mr. Taklal Singh will address your lordships on the question of bias. Unless your lordships have any questions on that.
Could you hold for me? I'm speaking to David. The board is content that you deal with bias on your reply. and if necessary, time saved here can be allocated to that. But the board needs to be persuaded that there is substance in the allegation of bias.
Thank you, my lord.
Thank you. Mr. Jeremy.
Thank you, my lords. My lords, I have just a little bit more time than I had originally budgeted for. What I want to take the lordships to would be, I don't have, of course, I'm the respondent to the appeal. Sure.
Sure.
Thank you. My time, my lords? So I expected to have 15 minutes, of course.
Yes, you have a bit more than that if you wish it, yes.
Thank you so much.
We will have the short adjournment at 1 o'clock.
At 1.
At 1 o'clock.
Okay, good. Thank you. My lords, I am the respondent. We are the respondents to the appeal, so we don't have a right of reply. But there were two matters that I felt that I needed to, at the outset, address your lordships on. And the first concerned Romilla Maraj. Now, if your lordships would recall, that was the witness of the appellant, the now appellant, that the judge in the court below, the High Court, expressed confidence in. But I should like to point out just one or two things, no more, about that witness and what exactly the judge said in terms of his confidence. And if necessary, I'd like to carry you to the transcript. So, what the judge actually did see was, perhaps I'll take you to the transcript. Now, we've already discussed the way in which the real-time company functioned in relation to Mr. Lala. And in cross-examination in the court below. And my lords, I'm taking you now to the transcript. I hate to do that, but I am.
Well, we've been taken to it by the appellant. You can take us to the transcript as well.
I try not to. So, there are two things, and only two things, that I'd like you to note. At page 408 of the electronic bundle, 408
Yes.
of the EB. Ms. Mirage is being cross-examined respectfully, and she's asked if she, well, has ever, perhaps I should begin on page 406, just a page over.
Sorry,
406.
406.
Just a page over. At the bottom of the page. And here she's asked if well, the managing director, the answer to that is, of course, yes. And then she's asked if she knows Mr. Warner. There's a colloquial Trinidadian expression, do you know him from Adam? Have you ever known him? And her answer is at the top of page 407. She says, correct, that is, I don't know him. And then at the bottom of page 7, there are a couple of questions about.
So she didn't know Mr. Warner? Yes.
She had no knowledge of Mr. Warner from Adam, as we say in Trinidad.
Not just in Trinidad. Thank you.
Now, of course, your lordships appreciate that this is a woman who is a managing director of a company, but one which we've already established Mr. Lala has control over. At the bottom of the page, 407, she's asked about her relationship with Mr. Lala. And on the top of page 408, and this is in respect of whether this is a business loan or a campaign donation. She's asked a question. It begins and, but really, you are just taking Mr. Lala's word for it, that it was a loan. And she replies candidly and properly, and this is perhaps why the judge is impressed with her. Yes, she does not know. Okay? So that's enough of it. Now, just quickly, my lords, I'd like to take you to well, since I have a little more time, I think I'd begin in earnest. So, if I could, just on one further matter before I set out my stall, so to speak.
We're not pushing against you. You can take us to that matter.
So I'd like us to refer now to the particulars which were filed in the High Court after a long and protracted battle which involved a first visit to this board. So now, just to refresh your lordships' minds, that first visit is set out at 243, 244, EB 243, 244. and that is a filing of my learned friends in respect of this matter. So they speak of the previous appeal. And it's interesting to note that, my lords, are you with me?
Yes.
I have
43.
Yes, thank you.
In that previous appeal, the center now, that is Mr. Warner, applied to strike out the claim because there was a failure to plead certain details required by CPR 8.6. Now, it's not our business to ask why there was a failure to plead those details. Everyone knows what those details are. They did not plead them. Now, the judge who was then charged with case managing this claim struck out the claim. Mr. Lala now appealed to the Court of Appeal, and that time he was successful. The Court of Appeal held, and that's at paragraph 6, that the judge had the power at that stage of the proceedings to make an order for further and better particulars. And of course, in this board, that decision of the Court of Appeal was affirmed. So Mr. Lala's been here before. Now, when he was ordered by the judge, pursuant to the decision of the board, to require the claimants to particularize their claim, all that he could do, and I'll take you now to EB 28. So, the actual document begins on EB 26, but I'm on EB 28.
The document is the further and better particulars. Yes.
That it is.
Yes. And within that document, you're looking at each paragraph.
Roman 4, the date of the agreement, and Roman 5, the purpose of the loan. In Roman 4, and this is the beneficiary of an order to provide further and better particulars, the claimant could only say that the agreement was made in or around August 2007, and evidence in each case in writing, not by a contract, by the issue and handover of each check to the defendant and the encashment thereof by the defendant. Those are the particulars. That's at Roman 4. At Roman 5, and this is what they see. Having achieved the gift of fresh proceedings, these are their particulars. They see Mr. Jack Warner represented to Mr. Krishna Lala that the defendant was experiencing difficulties in meeting its financial obligations including the payment of salaries, loan payments, and other expenses. Then they go on. The purpose of the loan was to assist and/or enable the defendant to meet these financial obligations until the defendant received the USD $10 million, which he was to receive in 2008.
Now, that was Mr. Lala's evidence, I think, which the judge did not believe.
Yes. So I take you to it, Lords, to say that they conceived of this, they pleaded it as a business loan, pure and simple, nothing else. It was pleaded as a business loan. Now, my Lord, these are points that I return to later on. If I can, I said I wanted to speak about two things. I thought I had 15 minutes to do that, and I thought I'd be rushed before launching into my bit.
Yes, but no doubt you have your substantive case prepared.
I do.
So I hope I'm not inconveniencing you by asking you to proceed with it.
I appreciate that.
Thank you.
So, my lords, my friends argue that the Court of Appeal was wrong when, and there are two findings of the court. By unanimous decision, they held that on these facts, they were entitled to set aside certain findings of fact which were made by the trial judge. Now, we refer to that ground as the findings ground. Secondly, it decided by a majority, so they were unanimous on the first. It decided by a majority that findings of the trial judge were tainted by bias, and we describe that ground, not surprisingly, as the bias ground. My learned friend will take the bias ground, and I do what I consider to be the heavy lifting.
Well, the reason that the appellant has not been asked to speak on the bias ground is that the board, on examination of it, at the moment is not persuaded that the Court of Appeal was correct to hold that there was a case of apparent bias. And for that reason, the board has asked the appellant to leave their commentary on that to their answer. So you will have to persuade us, in effect, that our initial reaction that there is not a case of bias here is incorrect.
And I'm sure that my friend will do the necessary on that. So, my Lord, I accept at the outset that my focus is on therefore, on the core finding of fact of the trial judge. Now, of course, there are certain other findings of fact which were made by the judge. Importantly, in this case, the judge found that the email evidence was authentic. We have a difficulty with that but I'll address you on that. So if I could begin with the core finding of fact. What is the core finding of fact? And it is that finding to which my learned friends have referred, which is to be found at paragraph 44 of the decision of the judge. Now, of course, it's repeated, the finding is repeated several times. It's repeated in my submissions, in their submissions, but I think that it's in the decision of the Court of Appeal. But I think perhaps that the best place to look for it is in the actual decision of the judge. Now that's at page 70, EB 72. And if I could, it's a paragraph long, but I'd like to read it because it is an important paragraph. It's perhaps why we are here. So the judge says this, and Lords, I come back to this paragraph later on and I dissect it. But this is the context in which I do that. He says this: when the court considered the evidence in the wrong, the emails, the subsequent events after May 2010, with the formation of the partnership government, so he's telling us all the things that he considered. I found on a balance of probabilities that it was more likely than not Mr. Lala advanced to Mr. Warner significant sums. So he uses the word advance there. But the sums advanced were made available pursuant to loan arrangements. Now, recall that in the pleadings and in the particulars, which Mullen and friends fought long and hard to have, the loan is a business loan. That is how they characterize it. The sums advanced were made available pursuant to loan arrangements. It is plausible and probable, having regard to the evidence of Mr. Philip and Mr. Hussain, as well as the various emails which outline the facilitation of a line of credit from Mr. Lala to Mr. Warner, to conclude that Mr. Lala and Mr. Warner forged a clandestine political alliance for the financing of the 2007 elections after they had agreed to have Mr. Warner replace Mr. Pandey as the political leader of the UNC. Thereafter, they engaged in a shadow election campaign which was conducted from Mr. Lala's office. This was done, it appears, in addition to and independent of Mr. Warner's involvement with the official Rienzi Complex coordinated campaign.
Just pausing there, do you take issue with those statements? Because they were the evidence led on behalf of Mr. Warner.
Yes, so up to that point, no problem.
No, but you accept that, and it was your case that the provision of money was part of a clandestine political alliance for financing the elections.
I would not have used that expression.
No, Well, clandestine has a certain pejorative
Yes, but
element.
it's hardly a basis for reversing the judge by itself.
Yes. I mean, what you take issue, obviously, is the first sentence about it being a loan, and you also take issue with the sentence you're about to read.
Precisely. So and that sentence is this, my lord. On a balance of probabilities, this court is of the view that Mr. Warner may have wanted to portray an image to the UNC that he was its main financier. But to do so, he sourced finance from Mr. Lala on the basis and expectation that the sums advanced would be repaid upon his receipt of an anticipated payment of $10 million US, which was due in February 2008. So that is the finding, my lord. And I pause there to see this. The judge, of course, found that the money was paid pursuant not to a loan, simpliciter, not a loan for business purposes, as alleged by the appellant, as pleaded by the appellant in his further and better particulars, but that the sums were made available pursuant to a campaign finance loan. And we see that the Court of Appeal that is a finding that the Court of Appeal was entitled to first interrogate carefully, I don't think that there can be any dispute on that, and two, to reverse on the findings of the facts of this case. And we say that for this reason. We say first, the way the case was pleaded. The case was pleaded from the outset as if the rival contentions were business loan, campaign finance contributions. That's the way the case was pleaded. Now, in the appellant's reply, and this is still on the pleadings, they maintained their position. They had a difficulty on the pleadings. The last check, which is in your bundle and helpfully dated, I can carry you to it, but perhaps I should do that.
The reply is at page 36 of the bundle, I think.
Yeah, the reply is at page 36, but the last check is at EB 25.
What is it in the reply that you're referring to when you say they maintain their position?
Okay, so perhaps, my lord, let me look at the check first, with your leave.
Okay.
Come back to that in 2 seconds. check. It's at EB 25. It's stamped at the top. November the 2nd,
25, did you say?
EB 25.
Thank you. Yes.
1st of November 2007.
Yes.
6 days before the election.
I think it was 3.
Sorry, 3 days before the election.
So there was a problem on the pleadings. Of course, the contentions are campaign finance. Look, you paid us a check at this time. And how do they explain that? And this is where I come to the answer to my Lord's question. In the reply, they say that the payments were made based on the agreement arrived at and had no bearing on the election date. That's at EB 36. So, coincidental.
So that case was maintained right through the pleading stage and the evidence stage through to trial.
My Lord, that is entirely correct. So,
Could you refer me to the paragraph of the reply again?
it's
8.
EB 36, paragraph 8.
Sorry.
Paragraph 8, page
EB 36,
36, thank you.
paragraph 8. Now,
It's clear that this was disbelieved by the judge.
yes, my Lord, but I'd just like to develop the submission so that, unsurprisingly, given the way the case is pleaded, the evidence follows a particular pattern. Campaign finance contributions, business loan. And I think the entire transcript repays careful reading. I enjoyed it. It repays careful reading. There are at a number of times in the transcript attempts by counsel on both sides to ensure that they're not overstepping the limits that they've set for themselves in the pleadings. So my case is campaign contributions. I'm asking questions and I want answers only on that. My case is on business loans. Counsel below is especially counsel below, is extremely careful to ensure that there is no hint of campaign finance attached to any of these transactions. So at this juncture, I'd like to take my lords through the evidence. Do we have time to begin?
Well, it's 3 minutes to 1 by the computer clock. If you're starting a new chapter, would this be a convenient place at which to adjourn?
Perhaps, yes.
Thank you very much. The board will adjourn.